and 2 of the petition as follows. Those paragraphs have been reproduced. If you get the judgment, you will see it there. So a combined reading of paragraphs 15, 16, and 17 of the petition, coupled with the particulars thereof, show clearly that the petition is premised on non-qualification of the fourth respondent. I find it necessary to state that the grounds for questioning the return at an election are stipulated in section 135, subsection 1 of the Electoral Act, that has been reproduced earlier. For the purpose of this petition, it is the ground stipulated in section 134(1)A that is relevant. In other words, the election of the third and fourth respondent as president and vice president is questioned on the ground that they are not qualified to have contested the said presidential election. I've considered paragraphs 18, 19, 20, 21, 22, 23, 24, 26, and 28 of the petition as relevant for determination of the petition, which paragraphs have been reproduced in this judgment. In response, the first respondent, that's INEC, filed a reply to the petition where it was averred in paragraphs 14, 15, and 16 of the first respondent reply to the petition as follows, which have also been reproduced. The second respondent also filed a second respondent reply to the petition, and also made their own averments in paragraphs 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, and 25, 29, which have been produced herein. So from the totality of the pleadings in the petition and the replies of the respondents, what appears from the complaint of the petitioner is that the fourth respondent, while still a candidate of the second respondent for Borno's Central Senatorial District, was nominated and did accept to be the vice president candidate of the second respondent. That this act violated the provision of Section 35 of the Electoral Act 2022 as it amounted to his double nomination. That in the circumstances, his nomination as an associate of the second respondent for the presidential election is void. That the result is that the third respondent was disqualified from contesting the election because he did not have a validly nominated running mate at the time of the election. The petitioner relied on Section 131 and 142(1) of the 1999 Constitution for his postulation. Section 131 and 142 sub 1 of the Constitution of Federal Republic of Nigeria as amended stipulate as follows. A person shall be qualified for election to the office of president if A, he is a citizen of Nigeria by birth, B, he has attained the age of 40 years, C, he is a member of a political party and is sponsored by that political party, and D, he has been educated up to at least full certificate level or its equivalent. 142(1). In any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running mate for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate is for election to the office of president who nominated him as such associate is duly elected as president in accordance with the provisions aforesaid. The general principles of interpretation of the Constitution, which is the supreme law of the land, is that mere technical rules of interpretation of statutes are to some extent be avoided in a way as not to defeat the principles of government. That's why the words used are clear and unambiguous. A literal interpretation should be applied. In the interpretation, therefore, the provisions of the Constitution are to be accorded holistic interpretation so as to avoid ambiguity and arrive at the true intention of the legislature. The court must limit itself to the words used in the Constitution without resort to any external aid or materials. See the cases of Sani and President Federal Republic of Nigeria, Amadi and INEC, and Agi and PDP and others. Thus, in Wike Ezonwo Nwesom, Honorable Dr. Kuku, Adol, Peterside, and others, the Supreme Court observed that, I quote, the principle of conception of the Constitution to the effect that a Constitution is a living document, not just a statute, providing a framework for the governance of a country, not only for the present, but for generations yet unborn. It was held that in construing the Constitution, undue regard must not be paid to merely technical rules, because in doing so, the objects of the provisions as well as the intention of the framers of the Constitution will be frustrated. Courts have always been encouraged to adopt a broad and liberal spirit in interpreting the provisions of the Constitution, while constantly bearing in mind the object which such provisions were made to serve, close of court. That being so, where the Constitution has stipulated the qualifications to be attained by a person contesting or seeking to contest for any elective office created by the Constitution, the courts cannot create or import into the Constitution any other qualifying or disqualifying factor. This has been the position of the Supreme Court and dutifully followed by this court. It has therefore been held that qualification or disqualification of candidates to contest election is exclusively determined within the context or scope of the Constitution, and that nothing can be added to it. In other words, the Constitution, being the ground norm, is superior to any other law, including the Electoral Act. Therefore, where the Constitution has qualified a person or candidate to contest an election, no other law except the Constitution itself can disqualify him. The petitioner in this case has premised his complaint of non-qualification or disqualification of the third and fourth respondents as the president and vice presidential candidates of the second respondent on the issue of invalid nomination of the fourth respondent. That the fourth respondent, while still the senatorial candidate of the second respondent for the Borno Central District, allows himself to be nominated as the vice presidential candidate of the second respondent for the same election. In our rulings earlier delivered on the motions and preliminary objections, we had ruled that the petition grounded solely on the issue of invalid nomination or improper nomination is not a cognizable ground of disqualification under the Constitution. In other words, the claim in the petition that the third respondent was not qualified to contest the presidential election because he nominated an associate whose nomination was invalid does not flow from any ground of disqualification of a candidate to the office of president as stipulated in section 131 and 137 of the 1999 Constitution. See the cases of Balewa and Muazu and Faleke and INEC, Tazu versus Iorea. Then in Shinkafi versus Yari, the Supreme Court held that the Supreme Court has listed in section 182, section 182 very exhaustively all the issues that can qualify a person from contesting the office of governor of a state. From the record of this court, the facts have not disclosed any evidence to show that the first respondent was not qualified to contest elections into the office of governor of Zamfara State. It is my view that once a candidate sponsored by his political party has satisfied the provisions set out in Section 177 of the Constitution and is not qualified under Section 182, subsection 1 thereof, he is qualified to stand election to the office of governor of a state. No other law can qualify him. This authority can apply mutandis to Section 131 and 137 of the Electoral Act. It has not been contended by the petitioner that either the third or fourth respondent is trammeled by the provisions of Section 131 or 137 of the 1999 Constitution. The complaint of the petitioner rooted on nomination and sponsorship of third and fourth respondent will find accommodation in a pre-election dispute, which the petitioner cannot even pursue, not being a member of the second respondent. This Section 84, subsection 14 of the Electoral Act 2022 and 285(14) of the Constitution. While I'm tempted to put an end to this petition at this stage, but realizing that this court is not the final court on the matter, I'm constrained to look at the merit of the petition. As pointed out earlier in the course of this judgment, a complaint of the petitioner in this petition is that the third respondent was at the time of the presidential election held on 25th February 2022 not qualified to contest the election. This is because, according to the petitioner, the fourth respondent was not qualified to run on a joint ticket with him, that's third respondent, as the fourth respondent nomination was invalid for double nomination, which violates Section 55 of the Electoral Act 2022. As stated earlier, the petition contended that the fourth respondent was a candidate of the second respondent for the Borno Central District when the third respondent nominated him as his vice presidential candidate on the 14th July 2022. In other words, that at the time the fourth respondent was nominated, he had accepted nomination as the vice presidential candidate of the second respondent. He was still a validly nominated central candidate of the second respondent for Borno Central District. The petitioner then contended that the second respondent had earlier submitted the name of the third respondent together with that of the fifth respondent to INEC as his presidential and vice presidential candidates for the 25th February 2023 election. However, that before the date of the election, the fifth respondent withdrew his candidature as the running mate of the third respondent on the 24th June 2023, and the name of the fourth respondent was then submitted to INEC, that's first respondent, on the 15th July 2022. That the second respondent did not conduct any fresh primary election for the purpose of picking another running mate for the third respondent after the withdrawal of the fifth respondent. The respondents conceded that the fourth respondent was ab initio the central candidate of second respondent for Borno Central District. However, that on the 6th July 2022, the fourth respondent via a letter dated the same date notified his political party, that second respondent, of his withdrawal from the central candidature. That upon receipt of the fourth respondent letter, the second respondent immediately notified INEC, and which notification letter was received on the 13th July 2022. That the same letter also notified the first respondent of his intention to conduct a fresh primary election for the replacement of the fourth respondent following his withdrawal as a central candidate. That it was until 14th July 2022 that the fourth respondent was nominated as the third respondent associate for the presidential election of 25th February 2023. The fifth respondent notice of withdrawal as a candidate is in evidence as Exhibit PA2, while the notice of withdrawal and letter of voluntary withdrawal of the fourth respondent are in evidence as Exhibits PA3 and PA4 respectively. It will appear that the petitioner is the view that the fourth respondent was still the central candidate of the second respondent as at the 14th of July 2022, when the fourth respondent was nominated as the vice presidential candidate of the second respondent. However, the respondents contended that the issue of alleged double nomination of fourth respondent has been determined finally by the Supreme Court in People's Democratic Party, PDP versus INEC, that in the circumstances, the said judgment of the Supreme Court constitute estoppel parem judicata and binding on the parties in this petition. Now, for a judgment to constitute issue estoppel, the conditions are earlier stated in the rulings. So the three elements must be present and coexist for a plea of estoppel parem judicata to apply. In the cases of Ito and Epe and others, Boja versus Amida and others, and Alexandra and others versus Lone Star Drilling Company Limited, all citation supply. It is obvious that the judgment sought to be relied on for the plea of estoppel is that of the Supreme Court, the highest and final court in this country. There is no doubt that the decision was final, and the issue that was determined by the Supreme Court is the same as in the present petition, with whether the fourth respondent breached Section 35 of the Electoral Act but by allowing himself to be nominated in more than one constituency. The petitioner has, however, argued that the issue decided by the Supreme Court was merely on the local standing of the PDP to question the nomination of the fourth respondent, the candidate of the APC, a different political party. That may well be so, but it is clear from the judgment, that's Exhibit X1, that the Supreme Court pronounced on the substantive issue of double nomination. Though Joro JSC, who delivered the lead judgment, declined to exercise the powers of the Supreme Court under Section 22 of the Supreme Court Act to pronounce on the merit of the case, the other laws of the Supreme Court proceeded to do so. It is settled law that that a contributory or concurrent judgment has equal weight as the lead judgment. It is part of the lead judgment and therefore has the same force and binding effect. The mere fact that a concurring or contributory judgment contains what is not in the lead judgment will not whittle down its binding effect. Thus, in Olu Fiagba and others versus Abdurrahim, my Lord Fabi JSC said, quote, the concurrent judgment has equal weight with or as a lead judgment. A concurrent judgment complements, edifies, and adds to the lead judgment when the justice adds its certain fact aspects which the writer of the lead judgment did not remember to deal with. Insofar as the concurrent judgment performs same for all the above functions, it has equal force with or as the lead judgment insofar as the principles of stare decisis are concerned. Now, it is apparent that the parties in Exhibit X1, PDP and INEC and other supra are not the same as in the present petition. The earlier decision, though, involved the first, second, and fourth respondents. The present petitioner was not a party in that case. That is why it was argued by the petitioner herein that Exhibit X1 cannot operate as to stop it from litigating the issue of dominant nomination of the fourth respondent. The respondents have responded that the judgment in PDP and Annex Exhibit X1 is a judgment in rem as opposed to judgment in personam. In law, a judgment in personam is a judgment against persons who are parties or previous to the particular suit or proceeding alone. It is referred to as judgment inter partes. It is a judgment binding on the parties to the action alone. A judgment in rem, on the other hand, is a judgment that determines the status of a person or thing as distinct from the particular interest of a party to the litigation. It is referred to as judgment contra mundum, binding on the whole world. It is therefore binding not only on the parties to the dispute, but even non-parties. Therefore, once the status of a person or thing has been pronounced upon by a court of competent jurisdiction, no person is permitted to assert the contrary of what that court has decided. See Black's Law Dictionary, 11th edition at page 1008. Demishola versus Bolarinwa, Yanati Petrochemical Limited and EFCC. Then Ladi Jobi and others versus Oguntayo and others, Petition Supply. It is no doubt that the judgment matter in PDP and INEC others X1 was in respect of the alleged double nomination of the first respondent as the vice president candidate of the second respondent in the 25th February 2023 presidential election. That is the same issue raised in this petition as grounding the disqualification of the third and fourth respondent in this petition. Pronouncing on this issue in this case, in the contributory judgment, my Lord Okoro JSC, who presided on the panel of the Supreme Court, held as follows, I quote, there is no doubt that the fourth respondent was at a stage nominated as a candidate representing Borno Central District, but upon being muted, he would pair with the third respondent as vice presidential candidate of second respondent, All Progressive Congress, APC, in the 26th February 2023 general election. He withdrew his candidature for the Senate before taking up the position of vice presidential candidate. Documents in the record attest to this fact. These are APC 1, APC 2, which were made on the 6th and 10th of July 2022, respectively, laws of court. After considering those documents, His Lordship concluded at page 7 of the control judgment that, quote, it is crystal clear that the two exhibits alluded to above, the fourth respondent did the needful by resigning his position of Senate candidate for Borno Central District since 6 July 2022, before being nominated by the third respondent to run alongside him as vice presidential candidate of All Progressive Congress, close court. My Lord Okoro went on to, after citing Section 31 of the Electoral Act 2022, held at page 8 of his contributory judgment that I quote, the above provision of the Electoral Act 2022 was duly complied with by the respondent. It's my well-considered opinion that as at the 6th of July 2022, having withdrawn his nomination and personally served him on the second respondent of the withdrawal of nomination of on 6 July 2022, the fourth respondent was no longer a candidate for the Borno Central District elections, and his subsequent nomination as vice presidential candidate of the second respondent for the presidential election was not multiple nomination, as there was no longer a nomination for the fourth respondent since his withdrawal on the 6th of July 2022. I have also cited the elaborate contribution of His Lordship, Ajim JSC. So I have endeavored to quote extensively the dicta of the laws of the Supreme Court in PDP and INEC Supra in order to show that the issue of double or even multiple nomination of the fourth respondent as the central candidate and vice presidential candidate of second respondent in the 25th February 2022 general election has been settled to finality. It is a judgment in rem, therefore binding on the parties to this petition and in fact the entire world, including this court. Being the judgment of the final court of the land, this Supreme Court, no person is permitted to again raise and litigate on it in any other action or proceeding. It is therefore settled and remains settled that this petition, which questions the qualifications and seeks to disqualify the third and fourth respondents from contesting and occupying the seat of President and Vice President of Nigeria on ground of double or multiple nomination of the first respondent and Vice President candidate of the second respondent on ground of double or multiple nomination of fourth respondent has no substance. I only wish to add that Section 35 of the Electoral Act is targeted at the candidate and not the political party. That is why it uses the terms a candidate and normally allows himself to be nominated by more than one political party or more than one constituency. That's to prove that a candidate knowingly allows himself to be so nominated. Both the intent and actual acts of nomination, that is, the mens rea and actus reus of the act prohibited, must be proved, the stipulation in the section being a penal provision. In the instant case, neither the intent nor the fact of the first respondent to allow himself to be so nominated was established. That's why His Lordship Ogumi JSC, in his contributory judgment in Exhibit X1, held as follows, I quote, by Section 31 of the Electoral Act, the fourth respondent, Shetima, was obliged to submit a notice of withdrawal in writing to his party, which he did, and then his party is to deliver that notice to the Commission not later than 90 days to the election. In view of the above stated position of the law on this issue and the facts of this case, there exists no animus or display of intention by the fourth respondent to stand as the nominated candidate of the second respondent for the vice presidential position and also the senator representing Borno Central District in the general election of 25th February 2023. There cannot be any other interpretation in the circumstances unless there is clear intention to knowingly stand as a candidate for two elective posts in the same election cycle. Jim JSC also contributed as follows, quote, the manifest intention to relinquish the earlier nomination to pave way for the nomination of another person to replace him as the party's central candidate cannot be overlooked or disregarded. To simply isolate the assumed or purported short-lived coexistence of the two nominations for treatment as multiple nomination without regard to the obvious intention of the first respondent not to be the party's candidate in elections in two constituencies is against the legislative intent of Section 35 of the Electoral Act 2022. The sequence of the occurrence of the events is not what determines the existence of multiple nomination. It is the intention, design, or purpose to hold two or more nominations as candidate for election that shows that the person so nominated knowingly did so. Second respondent did not intend that the first respondent should be its candidate for Borno Central election and its vice presidential candidate for the presidential election. The first respondent did not understand or know that he was so nominated. The word knowingly in Section 35 of the Electoral Act must be interpreted broadly to include all its literal meanings. Barton's Legal Thesaurus, fourth edition by William C. Barton at page 356, is defined to include advisedly, deliberately, designedly, intentionally, learnedly, pointedly, purposefully, with knowledge, etc. It is clear to me, therefore, that from the oral and documentary evidence adduced by the parties on this petition, the intention and fact of knowingly allowing himself to be nominated in more than one constituency as alleged by the petitioner against the fourth respondent has not been established. In other words, both the mens rea and actus reus of the act prohibited by Section 35 of the Electoral Act 2022 were not established. One other aspect alleged by the petitioner on its claim of invalid nomination of the third and fourth respondent is that the second respondent did not comply with Section 33 of the Electoral Act in the nomination of the fourth respondent as vice presidential candidate. That after the withdrawal of the fifth respondent, the second respondent should have conducted a fresh primary election within 14 days for the purpose of nominating a new vice presidential candidate. Now, Section 33 of the Electoral Act stipulates that a political party shall not be allowed to change or substitute its candidate whose name has been submitted under Section 29 of this Act, except in the case of death or withdrawal by a candidate, provided that in the case of such withdrawal or death of a candidate, the political party affected shall, within 14 days of the occurrence of the event, hold a fresh primary election to produce and submit a fresh candidate to the Commission for the election concerned. The interpretation of this provision does not, in my view, cause any difficulty as to require the application of any technical rule of construction. Therefore, a literal interpretation will suffice. It therefore means that where a political party has submitted the name of a candidate pursuant to Section 29 of the Electoral Act Supra, it cannot be allowed to substitute or change that candidate except in the event of death or withdrawal of such candidate. By the proviso thereto, the political party affected is enjoined to conduct a fresh primary election for the purpose of producing a new or fresh candidate to submit to the Electoral Commission. The grounds of the petitioner here is that the fifth respondent withdrew his nomination as vice presidential candidate of the second respondent, but the second respondent did not conduct another primary election for the purpose of producing a new vice presidential candidate within the 14 days prescribed by Section 33 of the Electoral Act. It should be remembered that by Section 142, subsection 1 of the 1999 Constitution, a presidential candidate for election to the office of president has the sole discretion, authority, or power of nominating his associate who shall run with him in the election as vice president. The choice or nomination of vice presidential candidate is not the product of any primary election. Therefore, in my view, the requirement to conduct a fresh primary election does not apply to the nomination of a vice presidential candidate. Thus, my Lord of GJC highlighted this point in Exhibit 1 as follows. The fourth respondent was not required to buy any nomination form. He was the second respondent, APC's candidate at the election into the office of Senator representing Borno Central District. But before the election could hold, he was nominated as the third respondent's associate, who is to occupy the office of vice president. The fourth respondent did not buy a nomination form for the said office, and most importantly, did not contest any primary election in order to emerge as APC's vice president candidate. Close of court. The petitioner in paragraph 28(2) of his petition had averred and also contended in his final address that there was a gap of about 3 weeks between the period the fifth respondent expressed his intention to withdraw and his actual withdrawal or purported nomination, thereby invalidating the nomination of third respondent because the candidature of the third respondent had lapsed and was no longer in a position to constitutionally nominate a running mate. This contention of the petitioner is, however, misconceived. There is nothing in the Constitution which robs a presidential candidate of his right to nominate his associate, who shall be his running mate for the office of president. There is also nothing that invalidates the nomination of a new associate by a presidential candidate as his running mate after the withdrawal of a previous associate, so long as the nomination of the new associate was submitted to the first respondent 90 days before the election as mandated by Section 31 of the Electoral Act 2022. This contention of the petitioner is therefore discountenanced. It is therefore my view that, that the position of a person as vice presidential candidate not being subject to primary election, the provision of Section 33 of the Electoral Act 2022 would not apply. On that note, I hereby hold that the petitioner failed to prove the lone ground of his petition to the effect that the third and fourth respondents were not qualified to contest the election held on 25th February 2023 for the reason of double nomination. Having resolved the sole issue of this petition against the petitioner, this position is held to be devoid of any merit. Well, we'll rise for just 15 minutes and continue with petition number 3 and 5. I can see Dr. Levy moving up and down. So, as elderly person, I know what is going on.
My Lord, we're just wondering, sir. We just wondering, my Lord, if your brethren agree with your judgments or not.
Pardon?
I said, we're just wondering.
No, it's a consolidated judgment. They will give their contributions after we have read all the judgments.
Oh, my Lord, yes. Please. We just needed to know, sir.
Yes, they will give their.
Thank you very much, my Lord. Thank you, sir.
Call the court.
Well, so far.
The first part.